Hello, dear viewers.
My name is Ferdin Nouri, and I'm a migration consultant in Germany. As you know, I have already explained for you about the national ban on deportation, which in German it is called Nationales Abschiebungsverbot, in a different video in my this YouTube channel with its details. Today, I would like to explain for you about the family reunification with a national ban on deportation in Germany with all its details. For example, under which conditions a family reunification is possible with this type of a protection, which requirements you need to fulfill for that, and when and how you can and should apply for a family reunification with this type of a protection, and so on. But first of all, I would like to briefly explain for you something about the national ban on deportation. In fact, after you apply for an asylum at the Federal Office for Migration and Refugees of Germany, if you get a national ban on deportation, which in German it is called Nationales Abschiebungsverbot, in the decision sent to you by the Office for Migration and Refugees of Germany, it will be written that das Abschiebungsverbot des Paragraph 60 Absatz 5 des Aufenthaltsgesetzes liegt vor, which in English it means that the result of your asylum application is a ban on deportation based on Section 60, subsection 5 of the Residence Act of Germany. Or it will be written that das Abschiebungsverbot des Paragraph 60 Absatz 7 des Aufenthaltsgesetzes liegt vor, which in English means that the result of your asylum application is a ban on deportation based on Section 60, subsection 7 of the Residence Act of Germany. After you receive this type of a protection from the Federal Office for Migration and Refugees of Germany, you should refer to your respective foreigner's office, which in German it is called Ausländerbehörde, and take this decision of the Federal Office for Migration and Refugees with you and apply for a residence permit based on Section 25, subsection 3 of the German Residence Act. Then you will be given a residence permit based on this section of the Residence Act of Germany, which can be valid from 1 to 3 years, and it will be also extendable. When you apply for a residence permit in your foreigner's office, this office usually asks you to bring your national passport. If you don't have your national passport and it is not possible to get it from your home country's embassy or consulate, you can apply for a gray-colored passport called Reiseausweis für Ausländer, which in English means travel document for foreigners, at your relevant foreigner's office and get it from this office. For more information about this type of a protection and how you can get a residence permit and a gray-colored passport with this type of a protection, and to which countries you can travel with a gray-colored passport, you can watch my other videos on these topics in my this YouTube channel. In fact, a person who has got a national ban on deportation and based on that has got a residence permit according to Section 25, subsection 3 of the Residence Act of Germany, and wants to bring his or her spouse and minor unmarried children through a family reunification to Germany, he or she should, in addition to completing the general requirements for a family reunification to Germany, such as the provision of the living expenses only for reasons of international law or humanitarian law, or for the purpose of protection of the political interests of Germany, according to Section 29, subsection 3 of the Residence Act of Germany, a family reunification to Germany may be made possible for him or her. That is why, for a family reunification with a national ban on deportation, not only the family ties, but also all the circumstances that justify a humanitarian urgency is decisive for the decision on it. One of the humanitarian reasons can be, for example, that in the foreseeable future, a family can only live together as a unit in Germany. If the family members of the person who wants to bring his or her family to Germany through a family reunification have a permanent residence in a third country where it's possible for this person to go and live together with his or her family in that country, in such a case, he or she cannot bring his or her spouse and minor unmarried children through a family reunification to Germany. In this case, the existence of a humanitarian reason can in particular be assumed if the establishment of the family unit in the third country is impossible or unreasonable. According to Section 29, subsection 3 of the Residence Act of Germany, the following points indicate that the conditions for a family reunification of a spouse and minor unmarried children to a person with a national ban on deportation and a residence permit based on Section 25, subsection 3 of the Residence Act of Germany are met, and a family reunification with this type of protection and residence permit is possible. First, existing danger to life, limb, freedom, health, and etc. Second, the family has been torn apart by fleeing their country of origin. And third, in the foreseeable future, the family can only live together as a unit in Germany, otherwise a long-lasting separation would be caused. It is worth mentioning that with a permanent residence permit of Germany, one can bring his or her core family members through a family reunification very easily in comparison to a family reunification with a national ban on deportation. If the reference person in Germany has a permanent residence permit, the reasons of international law or humanitarian law or the reasons of the protection of political interests of Federal Republic of Germany are not evaluated. Only the other requirements of a family reunification, such as the insurance of the living expenses and etc., are being evaluated. Therefore, if you've got this type of protection from the Federal Office for Migration and Refugees of Germany, you should try to complete the requirements for a permanent residence permit in Germany and get it as soon as possible so that you can bring your core family members with it through a family reunification very easily to Germany. For more information about the requirements for a permanent residence permit with a national ban on deportation, you can watch my other videos about it in this YouTube channel. In fact, in addition to the special reasons which the holders of national ban on deportation and a residence permit based on Section 25, subsection 3 of the Residence Act of Germany must have so that they can bring their core family members to Germany through a family reunification, which I just explained them for you, the reference persons and their family members must also complete the general requirements for a family reunification. These general requirements are almost the same as it is for the holders of the other types of the residence permits in Germany who want to bring their core family members through a family reunification to Germany. Now I'm going to explain for you the general requirements for bringing your spouse through a family reunification to Germany. First, you and your spouse must be at least 18 years old. Second, you and your spouse must have a passport and an ID card. Third, you must have a proof of marriage with your spouse. This can be a marriage certificate, a nikahnama according to Sharia law, and a marriage registration certificate, and so on, based on the marriage system existing in your country of origin, or depending on your case, where you have married. Fourth, your spouse must have proof of basic knowledge of German language or A1 German language certificate. There are some exceptional cases based on which a A1 German language certificate is not a requirement for your spouse. For example, in case your spouse is permanently not able to learn a foreign language due to a physical or mental disease or disability, and so on. Fifth, there must be sufficient accommodation available for you and your spouse. Although the required size for the accommodation, which is sufficient for each person, differs a little bit from state to state in Germany, but in general, if you have 12 square meters for each adult and 10 square meters for each child of under 6 years of age, that should be enough. And sixth, your living expenses and the living expenses of your spouse must be insured, and you must not get any help from job center and from social welfare office or Sozialamt. However, in some exceptional cases, it is possible to bring your spouse through a family reunification, although your living expenses and the living expenses of your spouse are not insured by yourself. For example, if you have a serious illness or a disability based on which you are not able to insure your living expenses and the living expenses of your spouse in Germany, you can bring your spouse through a family reunification with the help of a good lawyer without completing this requirement. In addition, the person who wants to bring his or her spouse through a family reunification to Germany must have married before getting his or her residence permit in Germany, and it should be expected that he or she is going to have a residence permit at least for the upcoming 1 year in Germany. However, if he or she has married after getting his or her residence permit in Germany, he or she must have already had his or her residence permit for 2 years in Germany. Due to the fact that the requirements for bringing your core family members with this type of a protection and the residence permit in comparison to a family reunification with some other types of protections and residence permits in Germany are difficult, it is recommendable to apply for it with the help of a lawyer or a migration counseling office in your city or region if you have already completed the requirements for it. In order to apply for a family reunification of your spouse and your minor children, you should first register them in the website of German Embassy or German General Consulate in their respective country for an appointment with their full names, dates of birth, and passport numbers. You must also give an email address so that the embassy or general consulate can send the confirmation for this registration in this email address, and later they can also send the appointment for the interview of your spouse and your children in the embassy or general consulate of Germany in the same email address. The list of the documents the German embassies or general consulates expect from your spouse and your children, the forms which should be filled in, and the information about the amount of visa fee are usually available in the website of the same embassy or general consulate where your spouse and your children are registered for an appointment. So it is recommendable that after the registration for an appointment in the website of the German embassy or general consulate, this list and the forms are downloaded and prepared for the appointment in the German embassy or the German General Consulate. It is worth mentioning that a minor child of under 18 years of age who has got a national ban on deportation in Germany can unfortunately not bring his or her parents through a family reunification to Germany. However, in very exceptional cases, in order to prevent a very exceptional heart condition of the child, him or herself, or of his or her parents, a family reunification is possible based on Section 36, subsection 2 of the Residence Act of Germany. Thanks a lot for watching my video. If you would like to get similar important information about the immigration laws in Germany, your rights and duties in German society, the living conditions in Germany, and other such important topics, please subscribe and follow our channel. If you have any questions or remarks about today's topic, you can write it under this video and I will be more than happy to answer it for you.